All right, I think that's my cue, Jeff, right?
I think that is our cue. Our web host, Alec, is, I think, on the background here, and we'll remove his screen from the board, and then we'll be ready to go.
All right, well, good morning. We'll start in 1 minute here. We still got some people logging in. I see the participant number increasing every minute here. So a couple things as we get started here. Well, first off, my name is Matt Thompson. I'm the business bank and market leader here in the Twin Cities. I have business customers throughout the entire Twin Cities, as well as a lot of real estate owners as well. So very relevant topic for my group. With me is Jeff Peterson from Commercial Partners, Professor 1030. Is it Professor 1031 or Dr. 1031, Jeff?
I'll answer to either one.
Okay. And then we also have Brian Niemczyk. He's an attorney with Hellmuth Johnson. So the format today, I'm going to ask our experts some questions, kind of an interview format. We do have a chat feature on there that Alec will be monitoring for me. So if you do have specific questions you would like asked, you can certainly do that in the chat feature at the bottom of your screen there, and I'll try to get to that. For those on my team, if you text me, I will not see it, so please don't use the chat feature. That happened last time we did this, and I didn't get to most of them to the end. So without further ado, we're going to start with Brian Niemczyk, who I mentioned before. I don't know, Brian, you want to introduce yourself quick, and then I'll start asking some questions.
Thanks, Matt, and hello, everyone. Brian Niemczyk from the law firm of Hellmuth Johnson. I practice in many areas of civil litigation, including landlord-tenant law, and have been doing so for about 15 years, representing primarily landlords in every conceivable scenario involving the landlord-tenant relationship, including evictions. And I'm here this morning at Matt's invitation to talk about the eviction moratorium, both primarily state, but also the federal moratorium that we used to have, and where we've come from in that world and how things stand at this moment.
All right, well, let's go. I'll go with the first question here for you. I do have these typed out, so it's pretty obvious I'm reading them. I know the eviction moratorium in Minnesota is something which has evolved through this pandemic. So, Brian, how do we get to this point?
Sure. As I'm sure all of you know, there was an immediate response to the pandemic back in March of 2020 that involved both the federal government and the state government taking action to restrict the availability of evictions. At the state level, this took the form of an executive order from Governor Walz that basically stopped all evictions in their tracks that were pending and imposed serious restrictions on evictions for the entirety of the period that the governor was exercising that sort of executive order power. So almost immediately, there were orders preventing the eviction of anyone except for a very, very small slice of reasons. And those reasons did not include non-payment of rent, or just the lease is ended and someone's held over, or they have committed some other kind of material breach of the lease. Instead, the only reasons from March of 2020 through June of 2021 that someone could be evicted is if they seriously endangered the safety of someone, if they're committing certain types of serious crimes on the premises, if they're destroying the place, or if the landlord themselves or a landlord's family member wanted to move into the premises. Unless you had one of those reasons, you're left out in the cold as a landlord with no ability to evict. And on the federal side, for any state but Minnesota, there was a parallel restriction that prevented most types of non-payment of rent evictions first under the CARES Act and finally under a CDC type executive order. That federal moratorium expired this past summer. The Biden administration tried to revive it, and the Supreme Court decided that the CDC didn't have the power to do that. So it fell off entirely, I believe, in August. So at the federal level, if you're not in Minnesota and the state you happen to be in doesn't have its own restrictions, there is no more moratorium in place. And as we'll see, Minnesota's moratorium has changed over time. And as of the end of June, the executive order moratorium from Governor Walz was allowed to expire. And it was replaced by a law passed by the legislature and signed by the governor that phased out over time the restrictions contained in the moratorium. So almost immediately in late June, early July, the landlords could evict again for material breaches that weren't non-payment of rent or holdover type situation. So here we're talking about unauthorized tenants, unauthorized pets, failure to allow inspections, things like that. Those, I can tell you, were the things that were driving landlords crazy during the moratorium, the executive order moratorium period. It's one thing if someone loses their job and because of the pandemic, you can't pay the rent, and is communicating with the landlord about that, okay. I mean, it really stinks for the landlord, but it's something at least you can understand and appreciate. But if a tenant, for whatever reason, is just saying, ha ha, you can't evict me, I'm bringing in my 5 dogs and my girlfriend is going to live with me, and what are you going to do? That happened too, and those were the ones I found that drove landlords most nuts. But as of early July, those evictions were allowed again, and certainly we've seen an uptick in them, at least in my office, since that time. And the moratorium has phased down significantly since then, with, as of October 12th, there being no restrictions on evictions other than scenarios where there's a pending application for assistance from something called Rent Help MN, which I'm sure I'll get into later in this interview. But the moratorium in Minnesota has mostly phased down under the terms of this phase out legislation, leaving only some kind of vestigial restrictions on certain types of evictions, at least as of last week.
Okay, Brian, yeah, I read some of the limitations on restrictions. Can you talk a little more about that? Some people can't get evicted until June of 2022.
Yep. So officially under the moratorium phase out legislation, you can now evict a tenant who owes rent. And for that reason, you haven't paid rent for whatever reason, whether it's COVID job loss or anything else, it's like normal times you can be evicted. However, there is a lingering restriction on evictions for tenants who have quote unquote pending applications with something called Rent Help MN. And Rent Help MN is a government sponsored rental assistance program that tenants can go to for up to 18 months now of rental assistance, both actual rent and utilities and late fees and things like that. That you can make an application, and if you meet their qualifications, which mostly involve not making too much money, then you as a tenant can qualify for payment of all your rent. It goes right to the landlord. But the moratorium phase out legislation drafters were concerned about scenarios where lots and lots and lots and lots of people apply for Rent Help MN assistance, and the system gets bogged down and is taking weeks, if not months, to process applications. And in the meantime, someone's evicted for non-payment of rent, which is kind of what's happening. The system is taking several months at least to process most applications. And during that pending time, someone has an application that's pending, they can't be evicted for non-payment of rent. That restriction remains in place until next June.
Yeah, Brian, I think the last stat I saw was somewhere around 80% of the money's not been allocated yet.
Yep.
The government side. Okay, so
yeah,
very slow moving, of course.
Lots of federal money came into that system that just needs to be distributed by the Minnesota-based system, Rent Help MN, and their application process. I mean, every case is different. I've heard stories about 4 to 5 week turnarounds. I've heard stories about much longer periods. I know that just in the last couple of weeks, the Rent Help MN system has developed a definition of pending application, quote unquote pending application. And I've got it right here. An application is pending after, it becomes pending after the tenant submits every kind of piece of information that the system needs to process the application, and it remains pending until 14 days after the date of denial of that person's application. But the pending status can be extended through an appeal process. If you're denied in the Rent Help MN system and then you say, no, I should have been eligible and here's why, your application remains pending for the entire pendency of your appeal process for however long that takes. And this is where I see some potential for abuse, if your application is denied as a tenant, you can reapply 2 more times within 90 days of the denial of your application. And that starts the whole process over, and then you'll be pending for however long that takes for at least 2 more times until, if you try to reapply, I guess, a 3rd time, they, I guess, flag it or they pause it or make sure that you can't reapply again. But obviously, there's a potential for abuse by tenants.
Yeah. Okay. No comment, but I get what you're saying.
Yeah.
On a practical point, what's next after this is all said and done? What's next for the landlords of Minnesota as far as evictions go?
Yeah, so there's concern, as I mentioned, about the real ability of most landlords to evict most tenants based on non-payment of rent because of this rent help MN pending application thing. I can easily imagine scenarios of abuse by tenants, not only as I just described, but let's say there's several tenants living in a particular place, and mom applies and is denied, and runs out of appeals, and now dad's applying, or grandma, or something, and it feels to me like an enterprising tenant can always manage to have an application pending if you try to start an eviction action against them. Now, I'm not saying all of them will do that or that everyone will try to game the system like that, but I can imagine scenarios where that would happen. And I don't know yet exactly how the housing court referees or outstate the regular judges are going to deal with maybe what they see as people trying to game the system with pending applications. But it strikes me and certainly others in the industry as a loophole that a lot of tenants can use to remain immune from eviction until June of 2022. So that leads me to advise my landlord tenants about other options. Of course, if rent is the issue and you just really want the rent and you're fine with the tenant living there as long as the rent comes in, whether it's paid by them or by the taxpayers through the rent help MN system, then fine. Most low-income tenants will eventually qualify, and you'll eventually get a big check for all the back rent you owe, in which case, great. The problem is at least in large part solved, and you'll get paid your rent up to June of next year, at which point you'll have the option to evict a non-paying tenant. If that's not the issue and you have other plans for the house or apartment or whatever it is you're renting that don't involve this tenant, or if you just don't want to rent to this tenant or don't want to rent to anyone anymore, there are other options. Certainly most tenancies that say were a year long expired at some point during the pandemic. And so the tenants, at least the problem tenants, are month-to-month tenants. And under the various iterations of the moratorium until last week, no month-to-month tenancy or any tenancy could just be ended at its conclusion, either with a month notice or with no notice if it's just a year-long tenancy that ends. And that's changed now. You can give notice, say right now, for non-renewal of a tenancy at the end of November, and the tenant would have to move out by the end of November. And if they don't, you can start a regular eviction action in the beginning of December, and there are no moratorium-related limitations on the normal proceeding of that eviction action. So just the non-renewal option is a good one for landlords at this point. Ones who have the option between doing that and trying to evict for non-payment of rent should most certainly choose the holdover option. And of course, the whole panoply of other kind of eviction rights are back, including the right to evict for an unauthorized pet or noise complaints or whatever else, whatever other problem that amounts to a breach of lease that the tenant is causing. During the moratorium, those were mostly not allowed. Now they're totally allowed in exactly the same way they would have been before the pandemic. So the other options exist to the extent you've got a problem tenant. It's worth either examining the options on your own or talking to a lawyer about what the best strategy is for proceeding with an eviction action at this point, given the pending application with rent help MN restriction on the middle of next year. I'll also mention the unknown about how these cases are going to be processed in the coming months. Certainly the system is operating on unusual terms right now. There are no, I guess there probably are some, but there are very, very, very few non-Zoom in-person hearings for any civil case, including evictions. Certainly in normal times, you go to housing court on an average Tuesday morning, and there's 50 cases and 150 people shoved into those rooms and those hallways, and it's not a recipe for kind of COVID safety. And so everything is happening by Zoom. And the system has gotten really good at processing these cases by Zoom, but the system has been able to do that with a much reduced volume. Only the unusual kind of moratorium exception type cases have been happening. And if the floodgates are opening now, they're going to suddenly see a flood of new cases, and how the system is going to be able to deal with those is an open question. I know that they've taken steps to increase capacity to accommodate all these new cases, but whereas usually a case would be processed within a few weeks, it may be a few more weeks to get your eviction case through. And maybe within a month or two, it'll be more than a month. I don't know. I've heard predictions either way, but I think it's fair to assume that there will be delays at every step of the way if you're trying to evict someone within the next few months. It remains to be seen exactly how long those delays will be and what will be the sticking points, whether it'll be the housing court system or the sheriffs in scenarios where you're trying to remove someone through that process. I don't know. This has never happened before, of course, in any court in this state. And there's a lot of experts who think it'll go one way and a lot of experts who think it'll go the other way. I tend to come down on the side where I don't think the delays will be measured in months. I think they'll be measured in weeks, but there will be delays. And any landlord who wants to evict someone within the next few months should take that into account in their decision-making process, that it won't be as straightforward and as simple as you might imagine or as it would be in normal times, just because of administrative related problems. So I see in the coming months, in the coming 6, 7, 8 months, as we move towards the final removal of all restrictions, I see delays. I see lots of evictions made possible for holdovers, with continuing problems for anyone who wants to evict for non-payment of rent because of this pending application issue.
All right. Hey, we got a few more minutes here. Then we're going to transition to 1031. I see a couple questions on here. One, I think I thought if you had the zero balance program, you couldn't have Rent Help Minnesota as well. Is that your understanding?
My understanding is it's one or the other.
Yeah.
But I should say that the eligibility rules for both of those, it can be easily changed. I like to have that's law. So stay tuned on that to the kind of guides on both websites.
Okay, and this wasn't me who typed this. I sent out my login, and a lot of people logged in as me, but the lease, I know the answer to this one. So the lease ends on month to month. They just notify non-renewal and start the action. The answer is yes. I don't know if you can read this too.
Yep, I can.
The eviction is, yeah, okay.
Oh, yeah, if you end the lease and give a month notice until the end of November, you have to wait till the end of November to start the eviction action. But once the notice period is over and they're still there, they're holdovers without any lease rights whatsoever, and you can then proceed with an eviction on that basis.
Okay. And Kevin had another question here, or Ken, excuse me.
I see. If an eviction is initiated, can the tenant then react with the initiation of a Rent Help MN application? The answer is yes. Absolutely. And that's yes, that's an opportunity for abuse, in my opinion. It remains to be seen how that plays out, but certainly you can apply after receiving the eviction, and that would stop the eviction.
Does it stay the eviction, or do you have to refile your eviction at some future date?
You would have to refile it.
So more costs involved for the landlord.
Yes, more costs, but I believe the courts would probably allow you to refile it without repaying the filing fee.
Okay.
That would be my prediction of how they'll handle it. And I've seen when the federal moratorium was struck down by the Supreme Court in August, there was a flood of landlords who saw the headline and decided to file their eviction actions, even though those were illegal under Minnesota law. And I've had a few of those come back to me and say, hey, wait a minute, what do I do now? The judge kicked me out. But in those cases, the judges have been sympathetic and said, well, yeah, you can't do this right now, but if and when you refile, I'll make sure you don't have to pay a filing fee. So.
One on the 30-day notice on the CARES Act.
Yeah, I'm not sure about that, actually. I'm not sure the extent to which the 30-day notice remains under the CARES Act. For certain types of housing, the CARES Act did provide for certain restrictions of for federally backed housing. But I don't think that that remains for most purposes at this point, just that it expired by its own terms. Are the eviction procedures for residential rentals and commercial rentals the same? The answer is, under the law, almost identical, except for there never were any moratorium restrictions on commercial rentals. The moratorium applied only to residential. There are certain differences that are specific to certain commercial situations. Usually commercial leases have more protections for tenants built in, but that's a case-by-case scenario. Fundamentally, they're heard by the same courts and the same process. Commercial evictions, however, have no moratorium restrictions on them. I have never heard from Rent Help MN whether the applicant qualifies. Does the Rent Help notify landlords in a timely manner? They certainly notify landlords. Timely, I don't know about that. Depends on your definition of timely, I guess, but certainly they do notify landlords whether an application has been denied or not. It just may take longer than a landlord would want under any circumstances.
All right, I think
Okay.
we missed Brian. We'll come back at the end if there's more questions, I think.
Sure. Yeah, I don't think so. Thanks for everyone's attention. Hopefully this was helpful and can lead to some, I guess, strategic decision making when it comes to trouble or problematic tenants at this point, and navigating through the kind of intersection of both the eviction system and the Rent Help MN system.
Yeah, thanks. Very informational, of course. And again, if there's time at the end here, we'll might answer a few more questions on the topic. So thanks, Brian.
Yeah, no problem.
Okay, Mr. Peterson, we're ready to go to you now. Talking a little 1031 here. So I think there's some people on there probably could use a little refresher. Can you just give a basics on what the 1031 is, the rules, et cetera, et cetera?
Sure. 1031 comes out of the Internal Revenue Code. It's a provision that allows you to defer the recognition of gains when you sell real estate that's been held for investment or business purposes. And it requires you to acquire or replace your old relinquished property with new real estate that's also going to be held for investment or business purposes. Most people that are doing 1031 exchanges are familiar with the 45-day identification period, in which you must designate clearly and unambiguously what replacement properties you want to purchase. And they're familiar with the 180-day exchange period, the period in which you must receive your replacement property. This can be frustrating for taxpayers. These rules were designed by the Treasury to hamper or limit the number of people receiving this tax deferral. So these are not rules that were made up by qualified intermediaries or facilitators of exchanges. These are codified in the Internal Revenue Code and in the Treasury regulation. So you've got some barriers to getting this tax deferral: 45 days to identify, 180 days to close. And there's a curveball as we approach the end of the year. Remember that your 180-day exchange period will be shortened down to the federal filing deadline for the taxpayer. So if you file on April 15th, that could shorten up your exchange period unless you ask for and receive an extension on your federal filing deadline to push that out. So if you need your full breadth of the 180 days, be cognizant that your deadline for filing your tax return may need to be extended. I can go on and on about the nuts and bolts of 1031s, and I'm happy to address that as questions come up.
Yeah, let's go with some of the prepared questions here, then we'll get to the chat room here. But Obviously everyone on the call, I think, is really interested in the pending tax law changes. We've seen lots of them from the administration. So what's the update on 1031 tax law changes?
Well, even before he took office, now President Biden had proposed a cap on 1031 exchanges that would cap the deferral at $500,000 per year. And there was a very strong pushback from folks that do conservation easements, people that are in banking, people that are in building and development, and just a whole spectrum of real estate oriented trade associations and groups said, look, this is really going to hurt the economy, and the expected increased revenue is sort of a fallacy because people will just not sell their real estate and recognize the gains. They will just be locked into their real estate and won't recognize the gains because they're not going to sell because they don't want to get penalized with the tax. So the tax would act as a disincentive for velocity in the marketplace. So it wouldn't be a very good revenue raiser, and it would have a really adverse effect on real estate values and redeployment of cash in the marketplace. Also, I think there was a very compelling argument that, real estate owners, unlike owners of stocks and bonds, are paying taxes the entire time they're owning the real estate, because at the state and county levels, they're paying property taxes. They have ad valorem taxes on the value of their property. And furthermore, they pay a lot of taxes, or state deed tax and mortgage registration tax and other assessments that may be applied. So unlike other sort of vehicles for investment, a investor in real estate is being taxed while they're owning the property, just not by the federal government. They're being taxed at the local, state, and county levels. So for a lot of different reasons, I think the moderate Democratic faction of the party said, you know what, 1031 is not a very good pay for. It's going to reduce job growth. It's going to reduce property values. We got to keep this in the code. By the way, this year is the 100-year anniversary of 1031. So provision's been in the code for a long time to facilitate the transfer of capital to those segments in the marketplace where we need infrastructure. 1031 provides private infrastructure, whether it is housing infrastructure, warehouse, retail stores. There's a lot of private infrastructure that is funded through 1031 exchanges. And if the administration wants to encourage infrastructure, it's not just public infrastructure, the roads and bridges, it's also all of the private infrastructure that goes on, from boarding houses and so forth. So for a lot of different reasons, I think people rethought the attack on 1031 and said, you know what, this is not a good pay for. It's actually going to probably discourage and reduce collections at the Internal Revenue. So let's keep it in the code. That seems to be the consensus at this time, but we don't know. Congress will probably pass a reconciliation bill. It'll probably be put together quickly and assembled in a rapid fashion. And you never know what'll happen when they're working fast to get something accomplished. So we're staying vigilant because you never know what could get slipped in.
Yeah, thanks. That was an excellent update. So what are the trends in the real estate economy you're seeing right now, Jeff?
Well, it's very apropos that we had Brian talk about evictions. I have a lot of clients that have highly appreciated duplexes and single family homes. And the owners are getting tired of management and dealing with tenants and trash and toilets and collection of rent. And they are wanting to sell those properties and transition into other investments, whether it's triple net leased single tenant type of property or try their hand at some other aspect of commercial real estate. They're tired of dealing with the toilets and tenants and trash. And we're seeing some fear, at least in the Minneapolis metro area, that rent controls and more regulation of landlords will make that business even more difficult than it already is. The landlords in Minneapolis and St. Paul have dealt with increased property taxes and increased regulatory restrictions for quite a while. And many of them are gun shy of staying in that multifamily space in the close in metro area. So for some investors, they're looking at this as a great opportunity to sell at the top of the market and reposition into other segments. A lot of people like to go into medical office. Medical is very popular, and also other management-free, less onerous types of property are desirable right now. But we see a lot of business. By the way, in 2020, we did a ton of exchanges. It was a very busy year. In this year, 2021, we did almost as many exchanges as we did in the entire previous year by about July 1. So we had a great year in 2020. We're having an even bigger year in 2021 because the velocity in the marketplace is so fast. There's a lot of commercial real estate trading, and it's mostly the mom and pop investors that are doing this. This is the people that own small single family rentals, duplexes, fourplexes, 12 units. These are small investors or farmers or other business owners that are taking advantage of this high value, low interest rate environment to transition into other real estate investments.
I was going to ask you about that because we're seeing a lot of out-of-state money or, REITs, whatever, buying these things. Who's buying these from the mom and pops? Are they out-of-state money, big corporations, et cetera?
Well, it's interesting. There's a lot of young people that want to do what's called the housing hack. They want to buy a duplex with first-time home buyer assistance. So they have a low down payment, they have a low interest rate, they buy the duplex, they rent out the other side of the duplex, typically the larger side, and they use the rental income from their tenant to supplement the costs of the mortgage, the property taxes, and the insurance. If you do the housing hack well, you can almost live for free without having to deal with the expenses of ownership, because the tenancy, the leasehold, is covering a lot of your overhead for the mortgage, taxes, and insurance. Now, you still have a lot of ownership responsibilities. There's always things that break on a house and maintenance and unexpected repairs that come up. But a lot of young people are buying the duplexes, the fourplexes right now. They're first-time investors. Those entrepreneurial young people are driving then the mom and pops to have to exchange into something new or different. So we're seeing a lot of owner-occupied investment. By the way, it's a great time to be a seller, right? There's very little inventory, lots of demand. Cost of financing is incredibly cheap. I understand USBank has a rate promotion right now that's going on for a little bit longer. And we should talk about that because those low interest rates are driving the demand higher, and it is a great time to be a seller. It is, however, a very difficult time to be a buyer. And that's where people are having trouble with the 1031. And it's why I emphasized the 45-day and 180-day restrictions, because people are frustrated that they're being outbid or unable to lock down a replacement property with a purchase agreement because there's so much competition, particularly in places like Jacksonville, Florida, or in Colorado. Those marketplaces are extremely hot and extremely competitive.
Well, since you brought up, 2.95, that's the interest rates we're seeing, right? At least our promotion ends at the end of this month. So it's a heck of a time to borrow at that
sub 3
rate. Sub 3,
I mean,
yeah.
That is crazy.
It's gonna, it'll go up in November, but for now it's 2.95. And you brought up a point. Inventory is super tight right now. So what other options are there for people selling if they can't find that replacement property? They have other avenues, alternatives, et cetera?
Well, I mean, people are creative, right? They try to find solutions. One solution that does not work, but has come up with a lot of regularity lately. People say, look, I want to do a 1031 exchange. I'm going to sell my investment property and I'm going to buy a really gorgeous single family home. And then I'm going to move into that single family home and I'm going to rent out my old home. And like, tell them, look, you need to talk to your accountant because that replacement property that you're acquiring to complete your exchange has to be used for investment or business purposes. If you move into that home, your accountant may say that's antithetical to using for investment. It's personal use. And they say, well, no, I'm just substituting my old home as the new rental. I don't think the IRS is going to look at it that way. So there are a lot of people trying to create creative solutions. I don't know that all of those creative solutions are going to work out. So we got to be very mindful that when you're doing an exchange, you want to bring your accountant, your tax preparer, your tax attorney, whoever your person is, into this equation to have a resource for staying in the middle of the fairway where it's safe. We are seeing a lot of people going into the syndicated real estate investments that are offered by firms like Morgan Stanley, Ameriprise, Schwab, I believe, has it, and Cantor Fitzgerald has it. So these financial services firms are selling products that are regulated as securities, but nevertheless qualify for 1031. And so that's a real nice way to roll out of very management intensive property and put your money into a less management intensive, easy to own property that's basically mailbox money.
Yeah, Jeff, I saw one of the panelists questions from our participants is on the Delaware statutory trust in the 1031 exchange, and I think that's what you're referring to in the syndicated managed. Can you comment a little on the Delaware statutory trust?
Sure. The Delaware statutory trust is the entity that the syndicators put the real estate into. So at the top of the ownership, there's a trustee of the Delaware statutory trust. When investors come in and buy the beneficial interest in a Delaware statutory trust, those investors are deemed to own their proportionate share of the underlying real estate for tax purposes. So the DST is like the perfect vehicle now for syndicating real estate because it qualifies for 1031. So in these brokerage houses that in the past said, look, sell your stuff, pay your taxes, and give me the money, and I'll make up the difference with rapid and efficient investment. Now they can say, sell the property, give me the money, and I'll reinvest it into a 1031 compliant investment, and we'll manage that money for you like we manage the rest of your non-1031 money. So there is a strong, if you will, right now, trend to move from the management intensive property to the less management. That is a very strong trend as people see an opportunity to sell at the top of the market and transition to a place where they can now travel and relax and not have to worry about the unexpected ownership crises that always arrive with ownership of real estate. They're now be able to say, I own my properties rather than my properties own me.
Okay. Well, let's go over to the questions on the panel. I'll read them off to you here. I think
Sure.
You kind of addressed this one already. This is not me to type this again, but can the 1031 be used for unlike investment properties, office space into retail multifamily? I believe you already answered that. That is yes, correct?
Well, yes, but the like kind standard is so broad that almost any real estate in the United States will be considered like kind to any other real estate. So an unimproved farm, raw land, is considered like kind with the IDS Center in downtown Minneapolis. They're both real estate. It's just differences in grade or quality, but the character of the farm and the character of the IDS Center are both real estate. So you can do an exchange of real estate that may not be similar, but you can still exchange within the United States real property for real property. So I think that it gives you a lot of options for potential replacement properties.
Okay. That kind of gets to the next one here. It says, can you 1031 into land and get credit for the dollar value of the new construction value in addition to the replacement land value?
So what this person is talking about may be called a build to suit exchange. Normally, if Matt Thompson sells a $500,000 piece of property and buys as his replacement property a $100,000 piece of dirt, the service takes the position that once Matt Thompson owns that dirt, his exchange is done with, and any improvements that he makes on top of the dirt that he now already owns won't count for his 1031 exchange. The seminal case in that is called Bloomington Coca-Cola. To work around that, there is a mechanism under Rev Proc 2037 that allows the qualified intermediary to form an LLC, and the qualified intermediary buys the dirt using $100,000 of Matt Thompson's exchange funds and holds title to that dirt during the remainder of the 180-day period, during which time improvements can be constructed and brought into existence as real estate. If we can build up quickly, if you've got your permits, your architecture, your general contractor, your materials, you can quickly construct another $400,000 of real property value on top of that dirt so that you receive replacement property of equivalent or greater value. Because in a 1031 exchange, you typically want to buy property of equal or greater value, so you continue your investment. You want to reinvest all of your equity, your proceeds, and to the extent that you pay off debt on the old property, you want to offset that debt relief with either new debt on the replacement property or an infusion of cash from your own pocket. So value, equity, and debt are sort of accounting mantras, and a build to suit exchange is a great way right now to construct the improvements to your specifications and get new property that qualifies, but you only have 180 days to get enough value constructed. By the way, you also, when you do your identification, you're not only identifying the location of the real estate, but you're also identifying the property to be produced. So you may want to attach plans and schematics or drawings or a description of those improvements that are going to be constructed.
Okay, this next question, actually, if we were live, you would know what this is. This is Mr. Ron Jones. So at any rate, hope it doesn't mind. I just said who it was. And this will tie into a reverse 1031, another person asked, but does the 45-day identification period have to be done prior to the sale of the subject property for the 1031 exchange? Or can the identification be done after the sale, but proceeds would need to be held in a 1031 exchange trustee?
Not sure if I totally understood the question. When you're doing a forward exchange, that means you've sold the relinquished property first. The day of the closing of the relinquished property is day 0, and you have 45 days thereafter to make your identification. At midnight of the 45th day, the exchange will fail if there has been no identification made. You must send in the identification. According to the regs, it has to be sent by midnight of the 45th day. If you're doing a reverse exchange, then you're not identifying the replacement properties. You're actually identifying what relinquished properties you're going to be disposing of. So in a reverse exchange, you're identifying the relinquished properties. That's the property you're trying to sell. And there can be a situation where you're doing both a reverse and then a forward exchange. So I may park one property for Matt Thompson. Let's say I parked a $200,000 piece of dirt for him. We bought it first. Then he sells his relinquished property for $500,000. So we get the proceeds from his $500,000 sale in. I immediately transfer him his first replacement property. That's the one that we parked and had sitting on the shelf like a can of Campbell's soup. We delivered his first replacement property to him, but now Matt's also got a forward exchange going, and he can identify additional replacement properties within the 45-day period and receive them within the 180. So you could have two overlapping linear timelines, first for the reverse exchange and then for the forward exchange.
Okay, I'll ask a follow-up to that. So say you're at day 170, right? And you don't have your new property inked in, whatever. What are you just basically SOL, or do you and just pay the tax, or is there any options at that point in time?
Well, I've had clients that have gone down towards the end of the wire on their 180-day time frame. In one instance, it was a snafu with the bank. The bank, for whatever reason, could not get the financing finally approved. There was a problem with the exchangor's bank being able to finance their acquisition. The seller was willing, the buyer was willing, but the bank had some kind of difficulty. Without the bank's money, it's hard to get the replacement property closed. So we said to the client, why don't you approach the seller and say, I'd like to buy the property on a short-term contract for deed under which the buyer receives equitable title. The risk of loss, the right of possession, the obligation to pay property taxes all shift to the buyer or vendee under a contract for deed. And the purchase through a contract for deed is a neat way to get a deal done so that the client can acquire the identified property within the 180-day period. Now, in the Midwest here in where we are located in Minneapolis, Minnesota, land contracts for deed are very popular. They're frequently used in the Midwest. This particular client that we were working with was in New York. They don't do a lot of contract for deeds. They looked at us like that's illegal. Like, we're not familiar with that. That doesn't comport with what their understanding was. So depending on where you're at in the United States, geographically, the customs and practices may dictate how, creative you can be in trying to get that transaction completed within your very strictly construed 180-day time frame. Also, just as an aside, if you're directly and adversely affected by a presidentially declared disaster, there have been a lot of forest fires and hurricanes and floods and things like that. Occasionally, you'll find that you are eligible for some extensions, and that those extensions can extend your 180-day period in very narrowly construed situations. We don't see it a lot here in Minneapolis, Minnesota, but we do in other parts of the country. So that's always an avenue to explore as well.
Okay, I got a few more popping up here. We've heard this one before. They've commented before. How long would replacement property need to be used for business before they can move in and use it as a personal residence?
Well, I think this is a cognitive test. It's not an objective time frame test. So discuss this with your accountant, your priest, your rabbi, and everyone, because it's really a mental intent test. When you acquire the replacement property, your mens rea, your intention, has to be to hold it for investment or for use in your trade or business. That's the requirement. And there is a safe harbor that is applicable to the Airbnb, VBRO, intermittent rental pool kind of context, where if a client buys a replacement property and puts it into an intermittent rental plan, the IRS, under their safe harbor, tests 2 12-month periods. After you acquire the property, they examine those 2 12-month periods to make sure that you're primarily using it for investment or business, and that if you're taking personal use, it's not too much personal use. So we know that the IRS tests 2 12-month periods in the context of VBRO, rental pool kind of properties. So if that is the standard that's applicable to rental pool properties, 2 12-month periods for a total of 24 months, some tax commentators have said, to be on the safe side, before you change the use of the property, you should also accumulate 24 months of exclusive rental, so that you can say, I initially bought it with the intention to hold it for investment, and I actually did rent it out for a substantial period of time. I've had clients get audited who have moved into their replacement property. In one instance, the client won the audit. She had rented the property to an unrelated third party in an arm's length written lease, really received rent checks for 18 months. And she did get audited, but she won the audit. So I know they're looking at these deals. I've had other clients that have moved into their properties after 3 months. So a sad situation where a widower lost his wife, did not want to live in his home that he had resided in with his deceased wife. And so he moved into his rental property and started renting out his old principal residence. He did the substitution. And of course, that got him in trouble and he got audited. So there are always instances where things can change in the future. So your long-term intention may be sort of indeterminate, but your initial intention, your pure mens rea initially should be, let's rent this thing out. Let's rent it out for a substantial period of time. And then maybe in the future, we'll convert it to personal use. But right now, our mens rea is investment or business.
Okay. Thanks. Next one, have DSTs replaced TICs?
To some degree, the old TIC syndications have really fallen out of favor. There are still TIC syndicated deals out there. And there are instances where that's an easier way to put together a consortium of buyers. I see it more with the friends and family want to get together and buy a property as tenants in common. I also see it where developers want to bring in friends and family to buy the dirt that will eventually be a development, but they need friends and family to exchange into the dirt to take down the land. But by and large, I would say DSTs have replaced TICs as the modality for syndication. And there is an enormous amount of money going into syndicated real estate right now, particularly DST syndicated. There is not enough inventory in the securitized world to satiate the demand that there will be between now and the end of the year. And some of these firms are going to have troubles because there'll be clients knocking on the door wanting to get into the deal and the investment's already completely sold out. So there will be some unhappy potential exchangors that had hoped to get into these DSTs to find out that they were too late to the party.
All right, there's some other questions on here, but what other options are there to syndicate outside of DSTs?
There are oil and gas royalty programs. They're very rare, but there are syndicators that are doing oil and gas. I have had some of my clients go into those investments. At the beginning of the year, we had one that did it, and the proposed or projected revenues from this oil and gas royalty program were, like considered to be like 5-6%, but because gas prices increased, they're now getting over a 10% return, I'm told. So there is there are some other avenues other than just pure going to the big wirehouses for DSTs. Also locally here in the Twin Cities, there are some developers that are doing deals and are bringing in investors that are qualifying for 1031. They're carving out a TIC piece of the new development so that people can exchange in. So there's a lot of people that are finding creative ways to bring 1031 monies into their deals. But for the developers and the syndicators, you almost have to decide this is going to be a 1031 compliant investment because partnerships don't qualify for 1031. You cannot take your 1031 money and put it into a partnership, a multi-member LLC, or some regarded entity. That doesn't qualify. You have to, when you're doing a 1031, buy an interest in real estate for it to qualify. The DST is the unique exception to the rule because under the old land trust jurisprudence, you could buy an interest in a land trust, a passive land trust, and be deemed for tax purposes to own your proportionate share of the underlying real estate. And that's why the DSTs work so well for syndication.
All right, yeah, you brought up oil and gas. There's a question on here. Can you 1031 from oil and gas to land or other real estate?
You can exchange real estate interests. Not all oil and gas programs qualify for 1031. So you have to be very cautious because not every deal that is set up as an oil and gas deal will work, particularly the partnership deals don't work, because if you own a partnership interest, again, doesn't qualify. But it's a really interesting situation where you could, let's say that Matt Thompson fully depreciates his single family rental, depreciates it down to zero. There's nothing left but the basis in his dirt, the underlying land that he could not depreciate. Then Matt Thompson takes his profits in a 1031 exchange and parlays it into an oil and gas royalty program that doesn't allow depreciation, but allows a different kind of deduction called a depletion deduction for the theoretical depletion of the underlying oil and gas reserves in the land that is the subject of his royalty program. So you could trade one kind of deduction, the depreciation deduction that you fully exhausted, for a different kind of deduction called a depletion deduction. And that could create some tax efficiency during the time that you receive your royalty payments under the oil and gas program that would then offset or mitigate some of the tax hit on your income. So trading depreciation for depletion is a very neat way to pivot from traditional real estate into an oil and gas program.
Okay, we got time for a few more. I think I'll just let you know that we will send out Jeff and Brian's contact information if you want to reach out to them directly. As well as if you get some questions in at the end we don't get to, we'll try to have answers to those as well towards the end here. But we got a couple more minutes for a few more questions. I think we talked about, we didn't get to it very much. I mean, 2 questions on a reverse exchange. Can you talk about the reverse exchange a little more?
Well, right now, it is so hard to buy your replacement property in these tight constraints, 45 days to identify, 180 days to close. So a lot of smart investors are going out and buying their replacement property first in a reverse exchange because they know the easy part will be liquidating and selling their relinquished property. But the hard part is acquiring that replacement property. So we have one big Minnesota corporation, that a longtime company in Minnesota, that's buying a new headquarters building in a western suburb. They're buying the land. They're arranging for the construction in a reverse construction to build out their new HQ, their headquarters. And then once that replacement property is underway and they've made enough headway on the construction, the easy part will be the selling of their relinquished property. So lining up your replacement property, locking it down with either a purchase agreement or actually having the intermediary purchase it and hold it on the shelf for you is a way to ensure that you're going to have a replacement property to acquire. Otherwise, it's like musical chairs. And when the music stops playing, you better have a chair to land on to complete your exchange, or you're going to have to pay the taxes.
All right, Jeff. So we got a couple minutes left. We'll just, anything we didn't cover, any parting comments from you on 1031?
You know what? It is crazy how many people call me up and say, I closed last week, or I closed yesterday. I haven't cashed the check. And now I realized I want to do a 1031 exchange after the benefits and burdens of ownership have shifted. And I get calls from financial planners desperate to find an intermediary that will take their client's money and put it into a 1031 exchange after the relinquished property has already sold. That's too late. Once the benefits and burdens of ownership on the relinquished property have closed, the intermediary can't act as the qualified intermediary under the safe harbor because certain required notices and processes have to be put in place before that sale takes place, that benefits and burdens take place. So you got to set up your 1031 early. I feel like I'm being punked, like this is a spoof reality television show where we call up qualified intermediaries and tell them we've already closed on our relinquished property. Will you take the money? Because it happens with so much regularity. It's just crazy. So attorneys, accountants, real estate agents, bankers, tell your clients to make arrangements with the qualified intermediary well before closing.
All right. Well, thanks for that, Jeff. I appreciate you sharing your knowledge as you always do. So I appreciate that. And Brian, anything from you before we close it out here?
I just want to flag in the comments, I put a better answer to the CARES Act question. There is still a 30-day notice requirement for some very, very specific types of federally subsidized housing. So if you have one of those federally subsidized projects, you're probably working with a lawyer in any event, but you should talk to that lawyer about the 30-day notice provision to see if it applies to you and whether it materially limits in any way your ability to proceed with an eviction for non-payment of rent. It probably wouldn't, because most of the rent is paid by the taxpayers in the first place, but to the extent it becomes an issue, the CARES Act does still apply.
All right, well, it's 10 o'clock on the nose. We got to most questions. Apologize. When you get to yours, we'll try to get them answered either in email or some sort of format. But again, thank you, Jeff, Brian. Appreciate it. Great topic as always. So with that, we're going to end the call. Thanks, everyone.
Thanks, everyone.
Thanks for putting this together, Matt. Appreciate it.